Uh, so good afternoon, everyone, in at least in the Eastern time zone. And I am going to share my screen so we can do the go. So you should be seeing my slides now. Um, please let me know if you can see them. Please send me a thumbs up or something if you can see the slides.
We can, if you want to press from the beginning, it'll actually go into the slideshow.
Okay. All right. So welcome everyone to a lunch and learn on 3 privacy breaches and, most importantly, what we can learn from them. Uh, and I, of course, for those of you who don't know me, am John McLean. I'm Senior Legal Counsel to the Government of Nunavut, and I have been advising on privacy about as long as I have been a lawyer, and in fact, since I was an articling student and a law student. Before coming to the GN in 2010, I was working with the Information and Privacy Commissioner of Ontario. In fact, I often joke that I think they hired me in the GN because I knew about privacy, that and I can bake. So today we're going to talk about, well, exactly what we're talking about, 3 privacy breaches. And of course, I will leave you the standard disclaimer. I'm a government lawyer. I'm required to give it. The opinions I'm expressing are indeed my own. And this is informational purposes only, not legal advice. So where we're going today, we're going to talk about, first of all, we're going to define some terms. We're going to say, what's a privacy breach? What is it that we're talking about? And then I'm going to give you 3 examples, true stories, of 3 fairly indicative types of privacy breach, how they were caught, what happened, and what we learned from them. What are some lessons coming out of them? So, and then of course, always have time for questions. This is sort of how we learn. So let's start with some basics, some basic definitions. And privacy is a legislated thing. So if you are working, advising a territorial public body within the government of Nunavut or Housing Corporation or Kulik Energy Corporation or any of the territorial public bodies, the relevant law is the Access to Information and Protection of Privacy Act. Starting to get a little long on the tooth. It is from 1994, but we were the first province or territory to have mandatory privacy breach notification built into our legislation for we've had it for about 10 years. And interesting, Ontario just adopted it for their provincial institutions. So we are occasionally ahead of the curve in law reform in Nunavut. So ATIP applies to all the territorial public bodies. Of course, the Federal Privacy Act applies to the federal institutions, all the federal government departments, agencies such as the Royal Canadian Mounted Police, etc. And then there's the Personal Information Protection and Electronic Documents Act, which currently applies to federal works and undertakings, as well as private sector organizations using personal information for commercial activities. Big asterisks next to this one. Bill C-27 is still before Parliament, currently working its way toward 3rd reading, which will replace the Personal Information Protection part of PIPEDA with the Personal Privacy Protection Act or Personal Privacy Management Act. The title changes. So it is currently going to be a major reform, the first major reform of federal privacy law for the private sector in 20 years. So,
John, just quickly, we're not seeing the slides advance. Can you press on from beginning?
Yeah,
it's in the.
I thought I was doing that.
And just while we're in the midst of this, John, I just wanted to thank you on behalf of the law side of Nunavut. Had a little trouble getting in here today, but here we are, and thank you again for agreeing to speak. Hopefully the slides will start working momentarily.
Okay.
Yeah, it might be easier to stop sharing your screen.
Okay.
And then share it back.
All right. Hang on, folks. So Now I'm going to see if I can share my, hang on. All right, so.
If we could see more of the presentation screen and less of you, John, we're
Okay, I
Yeah,
can
we
see if
don't
I can
need to-
change
we
that.
don't need to see you as so much as we need to see the screen.
All right, well, let me just fix that.
Presentation.
Yes. Okay, so I'm gonna change that. So, start again.
And if it's easier, John, I can also share your slides.
Would you just do that? You may have to
Yep.
advance just so we can keep going. I'm mindful of people's time.
Absolutely.
So while this is, while we're going up, we'll carry on. So, all right, there we are.
Yeah, that's good.
Yeah,
So I had-
and sorry, I'm gonna do one final interruption. And if it doesn't work, I mean, maybe we can just progress along it, Santana. Thank you.
So I think I had reached slide 6, Santana, so if we can start from there. And now we've lost slides. So while we're waiting for the slides, I'll just start on what would normally be in slide 6. There we are. So a privacy breach is any unauthorized collection, use, disclosure, or access involving personal information that is either in the custody or control of a public body, if it's a territorial institution, an institution under the Federal Act, or an organization under PIPEDA. So a privacy breach, for the purposes of our discussion today, is any unauthorized collection, use, disclosure, access. So if it's not authorized by law or authorized with the consent of the individual, any of that is a privacy breach. So next.
I don't think she heard you.
So yeah, so next one, please. Or if you can give me control, I can just advance them on my own.
Yeah, so unless you're sharing the screen, you actually can't advance them at the same time. So you just need to tell me when you need to go to the next slide. So we were on
All
slide
right, so
7.
so go to 7, please. So we're here on slide 7. So a data, now just so we're perfectly clear on terms and definitions, you hear the term data breach in the news a lot. You'll see it, you'll get notice, and if you work in organizations, you're constantly on guard against data breaches. And there is a distinction between a data breach and a privacy breach. So a data breach is any unauthorized collection, use, or disclosure to an organization's information or to the information within that organization's control. So it typically involves commercially sensitive information. A privacy breach always involves identifiable personal information. So it is like how all squares are rectangles, but not all rectangles are squares. All privacy breaches are data breaches, but not all data breaches are privacy breaches. And it gets to be important when you're looking at investigations and oversight. The privacy commissioner has oversight over privacy breaches. And one of the things about C-27 in the federal regime is that the privacy commissioner will have a wider discretion over data breaches as well. In the territorial legislation, the information and privacy commissioner has the jurisdiction to investigate privacy breaches. We tend in the GN anyway to treat all data breaches like they're privacy breaches until we have reason to believe otherwise. So we will notify the privacy commissioner and we'll move on. So next slide, please.
John, can you? Yeah,
They both-
it's moved on my side.
It hasn't on mine. Slide number 8. All right.
Thank
So
you.
thanks. Sorry about this, folks. So for today's examples, for those of you who know me and have worked with me, you'll know that I keep a file in my office called Scary Privacy Stories, because one of the things that I am constantly asked to talk about and give presentations about is personal information. It's ATIP. It's about access to information. So I keep a file called Scary Privacy Stories, and I had a difficulty picking just 3 today. But here are the rules for today's discussion. All are true. Every one of the privacy breaches I'm talking about is a matter of public record. So I'm not telling you anything that my clients wouldn't want you to know. Only one of them is a Nunavut example because I didn't feel like whacking my client for 45 minutes. One is from the United States, but it's just a really good example. And one involves a major national food service company. And each is the example of a common privacy breach, a commonly occurring breach. So next. Our first example is what I like to call the telltale blog. So next. So here's the breach. A mental health nurse working in a Nunavut community starts writing a blog called Life North of 60 in reference to her geographic location and her age. She did not realize that this blog was publicly available. She thought, to her defense, she thought it was only available to her subscribers or to people she had granted access, but it was a publicly accessible blog. It didn't name names, but the narrative, the blog entries revealed very sensitive information about conflicts with her roommates, who were also her colleagues, because in most of our communities, the nurses have to share accommodations. Imagine how much fun that is. And more importantly for us, that's a big deal, but more importantly for us, she was also revealing enough information that could identify sensitive information about her clients. So next. So that's a privacy breach. That's an unauthorized disclosure of personal information, of identifiable information. So the mental health nurse lost her job. That was it was a disciplinary matter. Mental health nurse no longer works here. The Department of Health issued a takedown notice for the blog, which she complied with. We had to notify the Information and Privacy Commissioner, who conducted an investigation. We had to notify the affected individuals. And to make sure it didn't happen again, we increased the frequency of privacy training. Next. So what can we learn from this privacy breach? This is a fairly common thing. Riffs on this we've seen are summer students who've never worked in a government before, never worked in a public sector institution before, didn't really get a whole lot of onboarding. They were just told, there's the phone, answer it when it rings. Go and rant on social media about what a horrible day they had. Well, it turns out they're revealing information about people who have come to the health center. So that is a privacy breach. In that case, that person wasn't terminated because they had never been given any training. So they were disciplined, they were given a warning, but it was a note to the employer that you have an obligation to do training. Regular privacy training for all staff can help reduce the risk of breaches. And My pet peeve working in institutions is that privacy training is never one and done. It's never, we did this in 2005. Why are you asking me to do it again? Um, Particularly in institutions and organizations with a lot of staff turnover, you're basically never not doing privacy training. It should be part of the onboarding process, and even the refresher course for people like me who've been around forever still could deserve a privacy. You could need a privacy refresher every now and again. And also in jobs and locations where you have constant staff turnover, people tend to revert to the last place they worked. So they'll remember the rules from the last place they work, but not necessarily where they're working right now. And the laws in Canada, privacy laws, are very similar, but they're not identical. So it is important to make sure that if you have rules, your employees know what's expected of you. And privacy breaches, the other thing we learned from this privacy breach is that privacy breaches can have professional consequences. And this is something regulators can get involved with. Nursing regulators, medical regulators, a breach of confidentiality, a breach of privacy. There are also code of conduct obligations and implications there as well. So this is a fairly common kind of breach, but it's one that's fairly easily remedied. So that's privacy breach number one. Let's move on to number two. Next slide. This is an oldie but a goodie, and it's what I like to call the privacy breach cup. And the law of unintended consequences. Next slide. So this is the one from the US. This is an American example. It's from about 2013, 2014, but it is well reported, and it's something that could happen in your institution. This was a healthcare setting in the US, I believe it was Pennsylvania. Nurses complain about the timed lockouts on their computer terminals. Any of us who work in institutions know that our screens will lock out for confidentiality and privacy purposes if we leave our desks for any length of time. The nurses were complaining about the timed lockouts, particularly in clinical settings. So the emergency room and intensive care, they were constantly having to put their passwords in. So this is taking away time from patients. This is a risk. And in an emergency room, seconds count. So they went to the IT department and asked for a solution. And we all know how that works. In this case, the IT department actually came up with a solution. They installed a sensor, a proximity sensor, basically, at every computer terminal, so that if it sensed that was a person standing in front of the computer, it wouldn't lock out. Problem solved, right? Well, no. Nurses discovered in this hospital how to bypass the sensor by taking a very large, like an extra large to-go coffee cup, and put it on top of the sensor so that computers will never lock out. So now everyone in the waiting room can see the patient information on the computer screens. So there's supposed to be a privacy protective measure, which the institution is required to have, that has been bypassed by the staff. Let's move on. Next slide. So what happened? In those cases, the nurses were disciplined, not surprisingly. The coffee cup was recycled. The hospital increased its privacy training. And the IT department went back to the drawing board and said, okay, we came up with a solution. It didn't work clinically. The nurses still had a point. So as much as this is a nice, the nurses had a point. If the seconds count and you need to be able to get into that screen, maybe the technological solution that IT department came up with wasn't working. So next slide. So this case is a textbook example of users finding workarounds for the employer's privacy and security programs. We all know this. We've all possibly done this. Every time an institution makes you put in a password with exclamation points and special characters and letters and numbers and things that are supposedly hard to crack, what do people do? They write it on a sticky note and they put it under their keyboard. It's a common thing. It's a workaround that negates the privacy protective measure in the first place. So it's also an example of employers instituting programs that may not be suitable for their environment, that we tend to be one and done or one size fits all in institutions. particularly multi-headed beasts like governments, where we have different program lines, where something might really work well in the engineering department, but it doesn't really work in the hospital, or it doesn't really work in the health center. And in some cases, this is also an example of IT solutions solving one problem while creating another much larger problem, which unfortunately institutions see all the time. The other thing we can learn is that whenever possible, institutions should be involving employees when coming up with programs and solutions, and they should be road testing them in sort of a safe environment. And they don't get deployed until you're sure that they're fit for purpose. It's again a common thing of talk to each other and listen to each other and come up with something that is actually appropriate for your environment. So let's move on to our final privacy breach. Privacy breach number 3. There's an app for that. Or coffee with a side of a privacy breach. So next. This, of course, involves Canada's largest and most popular fast food chain, Tim Hortons. They have an app. Why, I don't know, but they have an app. And you might have this app on your phone. And like everyone else who installs an app on their phone, you probably, even though you're all lawyers, you didn't read the terms and conditions. You just clicked accept. And now you have an app that can tell you where the nearest Tim Hortons is. And it can have your favorite order, and it can be right there on the counter when you get in, so you can skip that ridiculous line in the mornings. Starbucks has an app like this. I'm not picking on Tim Hortons just because it's Tim Hortons. I'm picking on them because the privacy commissioner did. They installed a new version of their app that would track and collect location data from its users, including when the app was turned off. And this is the problem. The users consented to the data collection, but according to the terms and conditions, which of course nobody ever reads, but even in the FAQ, the frequently asked questions, which people do read, it said, this is only going to apply when you have the app turned on. Tim Hortons intended to use the data for the purposes of targeted marketing. Basically, you're in Calgary. You normally live in Toronto. Here's where all the nearest Tim Hortons are. I mean, they've got big red signs out front. Like, how do you need an app to tell you where? Never mind. But you've got apps that track your locations. If you have a Google phone or an Apple phone, they're tracking your locations unless you go in and change your settings. So I'm again, Tim Hortons is just indicative. They never actually used the data in this case. They never actually did use the information, but they were collecting it. And more importantly, they could tell where this particular user who made the complaint, they could tell whenever he was visiting the competition. So they could tell whenever he chose to get his morning coffee at Starbucks or Second Cup or someone else. So next slide. So this naturally led to a massive investigation by the Privacy Commissioner of Canada, the Privacy Commissioners of Quebec and Alberta and British Columbia. Why the 3 provinces and nobody else? Is those 3 provinces have private sector personal protection information legislation. So they have an equivalent of PIPEDA at the provincial level that apply to provincial institutions and people carrying on business in the private sector. So typically when there's one of these big privacy breaches involving a national vendor, all of those commissioners do a joint investigation. If you look on CanLII, you'll see previous investigations about Canadian Tire or about Home Depot. Or the one I almost used was, and because this is near and dear to the hearts of people who go on duty travel a lot, it involved Marriott Rewards, which is now Bonvoy, because when they bought Starwood, there was the Starwood Preferred Guest. So if you ever stayed at a Westin, you probably had that card in your wallet. The points programs got merged, but some of the data got out of the barn, and it led to an investigation by the commissioner. You can read that one on CanLII as well. So commissioners determined that Tim Hortons did not have a legitimate need to collect the location data that they were collecting. More importantly, they did not obtain valid consent, because users were consenting to collect the data for only when the app was on, and they were collecting more than that. And what was interesting for us lawyers is they had some observations about the contract between Tim Hortons and its app developer, which incidentally was in the US, although nothing turns on that. The contract between Tim Hortons and its app developer contained vague and permissive language on how the information could be collected and how it could be used. So, as part of an arrangement with the Privacy Commissioner to avoid potential prosecution, Tim Hortons deleted the data and agreed to implement and maintain a privacy management program. So next slide. So the lessons learned, at least according to the Privacy Commissioner, is when you're talking about collection of information, you're talking about potential risk for privacy breach. Whenever you're collecting information, there's a chance it could get lost, or there's a chance it could be used. The commissioners spoke a lot about proportionality. When you're coming up with a new app, when you're coming up with a new thing, using personal information, is the loss of privacy proportional to the benefits of the commercial activity? So is collecting activity, but where all of your customers who have downloaded this app happen to be at any particular time, is relevant to your selling coffee and refined carbohydrates. You have to ask yourself, is it proportional? In that case, the commissioner said it absolutely wasn't. And for us lawyers, particularly those of us who draft contracts for a living, precise contract drafting can reduce the risk of privacy breaches. Better definitions, better undertakings, better wording in your contracts can really define who can use, first of all, what data is being disclosed and what it can be used for, and when you have to come back and ask for supplemental permission. So there's some precision in contract drafting, which the commissioner said did not exist in that contract between Tim Hortons and its app developer. And the other thing, most importantly, if you're a commercial organization, you should ensure that your clients understand how their information is being collected and used. And that is through things like clear and accurate frequently asked questions and other information. And yes, your consent forms need to be accurate and need to be honest and need to be in plain language, because no one's going to read those terms and conditions in 2-point font as they slide through an app. In fact, I know I'm probably going to get myself kicked out of the Law Society for this, but I'd be perfectly in favor of us abolishing 2-point font. No more fine print. All right, if we can move on to the next, just some concluding thoughts. Because why is this important? I mean, I've been telling you some stories, that some of them are funny, some of them are salacious. There's a cost to privacy breaches. And this is the slide when my clients start paying attention, because this is how it affects them personally. Privacy breaches can have huge financial costs. Every year, IBM Security, in conjunction with a think tank in the US called the Ponemon Institute, produces a document called The Cost of Privacy Breach. The 2023 report is out now. It's a free download. I download it every year. Because it really details the cost of mitigating privacy breaches. And it's been consistent throughout the life of this report. The cost of mitigating a privacy breach can be as much as 15 times higher than the cost of implementing a privacy and security program in the first place. And the global average cost of fixing a privacy breach is $4.45 million US, or $165 a record. And when you think about the human cost, any of those of us who had student loans in the mid-2000s know that the Federal Student Loan Office lost a hard drive with all our personal information on it. There was a class action, there was a settlement, and we all got a check for like $45 or something like that. But still, that's thousands and thousands of people that the Canada Student Loan Office had to pay out. And they had to pay their lawyers for dealing with all the litigation. There's also a reputational cost to a privacy breach. It erodes public confidence in your organization. And finally, there's an employment consequence. Employees who willfully breach privacy legislation can be subject to disciplinary action. Unintentional breaches probably won't result in disciplinary action. It'll be more corrective. It'll be more, this is a teaching moment, this is an educational moment, but willful breaches or malicious breaches can lead to termination. And in some cases, if you're a regulated professional, could lead to an awkward conversation with your regulator. And remember, folks, if you're in private practice, PIPEDA applies to you. You're an organization under PIPEDA. You meet the definition. of an organization, you have to have privacy policies. You have to have measures in place to protect the personal information in your possession, if your client's information, along with complying with whatever rules the Law Society has, and your code of conduct obligations around solicitor-client privilege. So next slide, please. So in summary, like nature, privacy breaches will always find a way. I don't know that we're ever going to get rid of them, but we need to know how to recognize them. We need to know how to stop them as much as we possibly can. And every time there's a new technology, every time there's a new big thing hitting the market, it opens the door. And remember, the people who develop that new big thing, those artificial technologies and IT and all the things that are in the news, that crowd that creates those things treats regulation as something to be avoided and something to be worked around rather than guidelines or guide rails. They see it as something to be avoided and to work around as much as possible. I mean, I think it may have been Google, it may have been Facebook. Their motto was go fast and break things. Like that's the IT industry does not, it resists regulation more than probably anybody else. So we're always going to be one step behind the technology in terms of regulations and rules. Preventing privacy breaches, and if you look at the ATIP Act, if you look at PIPEDA, its proposed replacement, if you look at the Federal Privacy Act is really weak on this, let's be honest, it's from 1983 and has not been updated substantially. But preventing privacy breaches will always engage physical safeguards. Those are things like locks on doors, access controls, security clearances, that kind of thing. Administrative safeguards, policies, procedures, training, technical safeguards, such as encryption, data masking, user access controls, that kind of thing. And you'll need typically any or all of the above to make sure you're keeping your personal information protected. As in all contracts, precision drafting really matters. And again, code of professional conduct. We are only supposed to give advice and practice in areas that we're competent. So lots of us probably don't know as much about technology as we could. We probably are not familiar with all the latest and greatest things. And I freely admit that I am in this camp a lot of the time. My phone is 4 years old, for heaven's sakes. I do not necessarily know what's going on. But this is when you engage subject matter experts. This is when you get external counsel or you get a consult. You engage somebody who drafts these contracts for a living. And this is what they do. And you make sure that you're being as precise as you possibly can. Because imagine yourself explaining this to the privacy commissioner someday. And I know he's not here today. He said he couldn't join. He sent his regrets. So I feel fine that I can name drop Commissioner Steele. But just don't feel that, imagine yourself explaining yourself to a regulator is usually my test when I'm standing in front of clients. You want to be able to have clean hands. You want to be able to show that you did everything you could and that you learn from your mistakes. And you have an obligation as a data custodian or personal information custodian to protect your client's personal information. We all have it. Now, those of us who work in institutions rely on very much the central agency functions of our employers to handle a lot of this for us. That I don't have any control over the IT department. I give them advice. They sometimes take it, but I don't have any advice. I don't have any control over how the IT department sets our password policies. But I know that they're there. And most institutions have that kind of security framework and cybersecurity framework. But for sole practitioners, for people in small institutions, small organizations, nonprofits, this is on you. And there are resources available. I mean, Privacy Commissioner Canada has a very useful document called PIPEDA and Your Practice, which is geared toward lawyers. It's an oldie but a goodie. I'm sure it will have to be revised when the new act comes into force. So next slide, please. So your sources are here. As I said, all of these reports are publicly available. The analysis is much deeper than I can provide in 35, 40 minutes. So they're there. And if you want to download that IBM security report, it is available. Just go into your search engine, the IBM Cost of a Data Breach Report 2023, and it takes seconds to download. So Next slide. So I'm happy to take questions and happy to answer anything as we go. I've been talking pretty rapid fire on this. I did try to keep it concise. But as those of you who know me know that I can talk privacy till I'm blue in the face. So I don't want to tempt that today, but if you have questions, let me know. But if you are the type that thinks of what you want to ask 20 minutes from now, or you don't feel comfortable asking it in the chat or in front of the whole class, pop me a note, pop me an email. I mean, I can't give you legal advice unless you work at the government in Nunavut, but I am absolutely happy to bounce an idea off. I'm happy to point you to resources. So good question already. Thank you, Jonathan. So asked to talk about the major highlights of the new proposed PIPEDA changes and how they'd relate. So good question. So PIPEDA will be going away. Well, part of it will be. The Electronic Documents Act part of PIPEDA will stay. It's going to be it'll just be called the Electronic Documents Act. The personal information protection side of it is going to go away. It's going to be replaced by another act, and there are consequential amendments to a bunch of acts. It will apply to the same institutions that PIPEDA applies to. So federal works and undertakings, federal incorporated businesses, and organizations, nonprofits, that kind of thing. How it applies to groups like the law societies, to the regulators, because we're not technically using information for commercial purposes, remains a sort of an open question. And when I was president, we certainly acted as though it did apply to us, even if no one has actually said it did, because there's a bit of a gap there if it doesn't. So there are additional safeguards around, there are new and improved requirements for institutions to have data security protections. There are also corresponding increased powers for the Privacy Commissioner to do investigations. There will be a private right of action for a privacy breach under the Federal Act, which is a new thing. Some provinces have a private right of breach of privacy. Ontario, it's called intrusion upon seclusion, and it's a common law thing. It's not statutory, but in other places it's a statutory tort. There will be a statutory right of action, so you will have a private right of action against people who breach privacy. There are administrative monetary penalties to institutions and organizations starting at $100,000. Currently, if you violate ATIP and we successfully take you to court, convict you, the maximum fine we could give you is $5,000 or 6 months in a territorial facility. So stay tuned on that. Legislative Assembly may be making some changes. But so PIPEDA is in the works. It's basically moving us along the line closer to the European model, closer to the European Data Protection Directive, which is sort of the gold standard for privacy law in the world. So we are moving a bit closer to that. There's also some there'll be new laws around artificial intelligence, etc. So Teresa asks, your thoughts on developing interface between data protection and the use of generative AI by lawyers? Are we anticipating changes to data protection and privacy laws? Yes. Ontario has just introduced a bill that will apply to provincial institutions there. I believe it's the Cybersecurity and Artificial Intelligence Act. I could be wrong about that. It's not law yet. It's still a bill. So that kind of act is generating itself. Our own Information and Privacy Commissioner, Kenny's not here, I can mention him, asked the GN to bring this under consideration next time we look at amendments to ATIP. So there is a possibility that we're looking at that. The federal legislation touches on artificial intelligence agents. What I will tell you about them right now is sort of garbage in, garbage out. It looks like fairly intelligent looking gobbledygook. And there have been cases, of course, they've been reported about people have written factums and other written submissions using generative AI, using ChatGPT, and the engine just made up cases. So I would be very, very wary, because you are an officer of the court, about filing things in court that you did not write or you did not verify. So be very careful about that. I'm by no means an expert. I know there was recently an LSN CLE on AI. that I'm sure you can go back and look at recordings and see again. It is the flavor du jour of CLEs this year. But what I can tell you is that the regulators, C27 has been before Parliament for at least a couple of years now. There was a previous version which died on the order paper before the election. The regulation is always going to be behind the technology by at least a year. And this technology develops so quickly. The regulations and the laws, we tend to draft them fairly vague. And of course, what happens in vagueness ends up in court, to quote the great Susan Hardy. Legislative drafters like precision. Thomas isn't here, but he'd tell you that. And so I don't know. It's a big.
Is there an
be
issue
very, very careful.
Using Chat GPT, for example, and the information that you're putting in and taking out gets into the universe, the AI universe, and you're revealing unintentionally client information?
Yes, that is a problem, because again, the generative AI systems get better. They get better based on the amount of data you feed it. So if you're feeding it client information and you haven't stripped out the client identifiers, if you haven't stripped that kind of thing out, you're potentially breaching solicitor client privilege and feeding it into an engine. Is anybody reading this information? No, but is it going to get cobbled together and put into an answer with somebody else? Possibly. So be very, very careful is all I'm saying. No longer being in charge of anything. But if I was still president of the Law Society, I would be really strongly suggesting no. Write your own letters, do your own analysis. So that is a problem if you're, because again, you're feeding the beast. But I'll give you an example of something that actually feeds generative AI in possibly a positive way. And that's Microsoft Translator. If you followed if you read the updates from the Government of Nunavut Communications Department, you'll see that Microsoft Translator now has Inuktitut as one of the languages. And for those of us who've worked and lived in Nunavut, you know that Inuktitut has multiple dialects. It can be written in syllabics. It can be written in Roman orthography. It is not the easiest language to translate. Microsoft is working on that. And in order to learn how to do that, the government of Nunavut fed it a bunch of publicly available documents, news releases, things that are already in the public domain. Nothing containing cabinet confidence or solicitor client privilege was fed into the box. And as a result, you now have a very basic version of Inuktitut translator in Microsoft Translate. The problem is, it's very, very good at government speak. It is not very good in the language that humans use. So the next phase will be taking other sort of non-government sources of publicly available public domain materials. So stay tuned for that. It's one of these things that's growing, but it's sort of, I think, generative AI being used for good. But again, we had the contract details exactly what they can and can't use. Anyone else? Questions? Privacy breaches, how to avoid them, what we can learn from them?
John, I just had a question, actually. This is Rebecca, about you talked about the fine print and the terms and conditions. I don't know if you've seen this study, but there's a study that was done at Heathrow Airport where they did they asked people as part of the terms and conditions to sign on to the Wi-Fi to give up their firstborn child, and pretty much everyone did it. So I'm wondering if it's the small print or if we're habituated just to agree to terms and conditions without reading them at all, ever.
I mean, Lord Denning talked about small print in contracts 50 years ago, probably more than that. He's been dead for 40 years. But it was the parking lot cases. The little tiny fine print on the back of a ticket in a parking lot, and it's just gotten worse because again, who reads the terms and conditions? I tell you, I do, because it's my job. That whenever the government of Nunavut has to sign on to embedded software to make the ultrasound machine work, someone in this office has to read it. So be kind to us. But those of us in our personal lives, whenever iTunes or Apple Music drops an update, do we actually sit down and spend time reading that? No. Famously, there was an investigation we can go back and read. I think the Auditor General did this one, where CSIS was using the fact that nobody reads the consent form in Toronto Pearson Airport Wi-Fi, that they were using. If you'd logged on to airport Wi-Fi at Pearson Airport in around 2007, 2008, they were collecting your location data for national security purposes, which was found to have been completely unauthorized by law. So yeah, there's a certain amount of buyer beware. There is an obligation to actually read things that, or particularly understand what you're consenting to, and do you really need that app that tells you where the next Tim Hortons is? It's right over there. But they have big signs. Um, and do you really want the good people that, but then like some of it, it's a pay to play. It's that if you've ever ordered Skip the Dishes or Uber Eats, or if you've ever ordered an Uber, there's a certain amount of, you have to give them their personal information, otherwise they won't serve you. So you have an obligation to sort of understand what it is that you're sharing, and who you're sharing it with. The old rule I was taught when I worked at the privacy commissioner, and this is in relation to social media posts, is don't put anything on social media you don't want the 5 Ps to see. That's parents, police, predators, principals, and prospective employers. Basically, keep those people in your head before posting on the New Nazi Act comments or wherever you might post on social media. Anything else? Hearing the silence, always remember you can send me a note if you think of something later. I'm happy to have a chat about anything to do with privacy or information management and access to information in government. Happy to have a chat. It's still a large part of my practice. We're all generalists at the Department of Justice, but it is something that I have a lot to say about and have a lot of information and involvement in. And again, the nice thing about openness and transparency in decision making is that all of the Information Privacy Commissioner's decisions are uncannily and searchable. And all of the Privacy Commissioner's investigation reports, Privacy Commissioner Canada's investigation reports, are all uncannily, and they're searchable. The Privacy Commissioner's website search engine is not amazing. Canley's is significantly better. So you can look this stuff up. And there are lots of fact sheets. There's lots of information and resources out there that the Privacy Commissioners of Canada have put out. Ontario is a really good resource. Alberta, BC are good resources because they have private sector legislation. And of course, in Nunavut, you may have seen links. There's a public survey out there because we are moving toward health-specific privacy legislation after talking about it for 15 years. There is a legislative project in the works. There's a public survey, and there are consultations coming to communities near you in Nunavut. So we will have health-specific privacy legislation applying to all health information custodians, anticipated coming into force sometime around 2027, but we'll see. So I thank you very much for your attention and for putting up with the technical difficulties we had at the earlier part of the presentation. And I wish you a very pleasant rest of the day. And I will hand it over to Rebecca if there are any housekeeping before we call it a day.
Well, I just wanted to thank you again, Jonathan, for your patience with our technological difficulties. And there's a certain irony in there when you're talking about some of the flaws and foibles of technology that we got to experience them. It was a teachable moment. So thank you again for your patience with that. And thank you for your contributions to the lost side of Nunavut. We do have other Lunch and Learn sessions coming up. If you look on our website for we still have a few running in the summer, and we'll pick up a few more in the fall. So thanks everyone, and thank you especially, John, for your really interesting and engaging presentation today.
You are very welcome. And again, my colleagues who are also teaching Lunch and Learns have lots of interesting things to say. So it is, when we brought in continuing professional development, I was on the executive at the time, and we made it very clear that you have to be able to get all of your hours in Nunavut, that you shouldn't have to travel out of territory to get your 12 hours of PD or 10 hours or whatever it is. So this is one way of doing that. And if you teach, you get extra points. Just putting it out there.
Thanks again.
Bye, everyone.